Okay, good afternoon once again, everyone. I would like to kindly call for our very keen attention. This is perhaps one of the most important sessions for this program. And one of the things I believe that the organizers and the bank would like to achieve is that at the end of this 5-day program, everyone in this room is able to provide an additional value add in terms of loan negotiations in your respective ministries and central banks. I've taken the liberty to translate, so just to give you a sense of what we'll be doing today. On the one hand, I will go through the very first portion of the slides, and then we'll get to a point where all of your very active engagements will be required. That part of the session will be where you'll be talking about how you would negotiate a clause. And so what you would see on your screen will be a sample clause, and I'll ask you, like we did in the morning session, what do you think needs to change here? And the expectation is that by the end of this class, I said it's a class yesterday, all of us will be mini lawyers who can effectively negotiate a loan document without needing to ask the legal counsel or the legal department. That's my plan, and I hope you would cooperate with me. So first, I would like to give a background. We would have a review of the landscape of sovereign debt in Africa. We did that on Monday, but just a very high-level review for the purpose of this conversation. We'll talk about types of lenders very briefly. I'm sure we know them. We'll talk about types of credit facilities or type of loan agreements, and then we'll go to the negotiating point, which is where I talked about us contributing to what we think a particular clause should look like. And you already know with me, everyone is up for the taking. And so, again, it's not to put anyone on the spot, but for us to be able to share and have cross-cutting ideas. And finally, there will be enough room for questions and answers. I suspect that we may not be able to conclude all of this within the time allocated. I'm trying to get to 1 p.m., and so we can go have lunch. It's possible that when we come back, we're supposed to have another session, but then I would continue on this session given how germane it is to our work. And the other session may be shifted to another time that I will be handling, perhaps tomorrow on Friday. Thank you for your very keen attention so far. So imagine with me for a second that you are, as a debt manager or central bank governor, are required to sign a check of $89 billion this year. That is exactly how much Africa needs to pay in external debt servicing for this year alone. That is a quarter of how much the GDP of the African continent is. Most of our funding is going towards debt as opposed to critical sectors like healthcare, social services, and education. And so you can see from the screen that Africa's debt is projected to exceed $1.3 trillion this year. Historically, we used to rely as a continent on concessional loans, which we described earlier this morning, both from Paris Club and the multilateral institutions. And in the past decades, in the last 2 decades, non-traditional lenders like China, as you can see on the screen, like Saudi Arabia, like India, have joined the bandwagon. And you can see, for example, that China's debt rose from 1% of Africa's debts to 14% estimates as of today. So whilst multilateral institutions have continued to play a very critical role, what we are seeing also on the continent is a rise in Eurobonds. And as you know, Eurobonds are as expensive as they come. And so the bond market in Africa has witnessed substantial growth, as I noted there. And we are seeing a lot of ESG bonds, green bonds, and also just the old, normal, plain vanilla Eurobonds. So this is a representation graphically of how debts in these 7 countries have been increasing and reducing, or forecasted to increase and reduce by the International Monetary Fund. So types of lenders, we know them already because we spoke about some of them today. We know about multilateral creditors. I wouldn't belabor the point. Regional, etc. If there's anyone that anyone needs clarity on, please feel free to drag me back. And of course, on all of these types of lenders, I took the time to introduce what they do, their loan terms, what we can expect from their loan terms, and their pros and cons. And so you can see that for multilaterals, their pros are low interest rates, but their cons could be slow disbursements, and their loans, as I'm sure many of you are aware, that are rigid in terms of the policies they require. And all of that is on the screen, and I'm sure you will get the slides. I do not want to belabor this point. Types of credit facilities. And so this is where it begins to get a bit interesting, or more interesting. And we have term loans. And what is important for you to know about term loans is that first, they're very common, or one of the most common types of loans. And they are usually for a fixed period with pre-agreed terms. I'm sure the organizers will share the slides, and so we don't need to worry about taking a picture, but obviously you can if you want to. And so the second type is a revolving loan, or a revolver. And what typically happens is that a country has an arrangement with a creditor, and the expectation is that there is a facility within which the creditor will advance certain amounts to the country per time after an initial disbursement has been used up, or the conditions of utilizations have expired, and then the country wants to draw more. So it's like a revolver. If you know what a revolver is, just think about a vehicle tire. And so the vehicle tire continues to run, and that's what a revolving loan looks like. It continues to go forward so long as the initial terms have been agreed and have been complied with and have been paid. Now, one thing to note about the negotiation of revolving loans is that there is first the inclusion of a commitment fee. Now, because your creditor has money stashed out for you that you can draw on per time after you've used the initial disbursement, they will typically charge a commitment fee. That commitment fee is usually up for negotiation. And so it's something you want to think about whilst you're looking at a revolving loan facility agreement. Then we go to a bridge loan. A bridge loan, like the term says, is a facility or money disbursed for the purpose of allowing you to undertake short-term liquidity concerns. And so what we have on the screen is that it allows you to cover immediate funding needs until long-term financing is secured. So say, for example, you're trying to get a loan from the World Bank. And the World Bank sometimes can take its time with all of its internal processes. But you need that loan to pay salaries in your country ASAP. What do? You go to a bank and say, you know what, I need a bridge loan of this amount. It will be paid back to you in 6 months, by which time the World Bank's processes will be done and would have the World Bank's money. Now, as you can imagine, because a bridge loan is very short term, they are usually quite expensive. So the amount for a bridge loan is something that is always up for negotiation. I believe you can see on the screen also is a standby credit facility. Now, the way standbys work is like I have my computer here that I refer to every so often, but also I have my tablet here. Now, I'm not using my tablet, I'm only using my computer. But if for any reason my computer goes off or there are issues with my computer, I refer to my tablet. That, in simple terms, is what a standby credit facility could look like in reality. So it's a facility that is just waiting for you, and it differs from a revolver because a revolver is an ongoing facility. You have already entered an agreement, and you are collecting money, and when that money finishes, you pay back, and then you take new money. But with a standby facility, there's a chance that you will never withdraw from a standby facility. But what you do pay is a commitment fee because your creditor is keeping that money aside for whenever you might need it. So think about it like an insurance. You don't have the money, or you don't need the money now, but there's a chance that maybe in the next couple of years, the projection of the commodity in your country, say it is gold or oil, would plummet. And if it plummets, you may need capital reinjection. Well, a standby facility could be there for you at the time you need that reinjection without needing to go through the rigors of fresh negotiation or looking for loans. And then all of these loans can either be secured or unsecured. And when we talk about secured loans in law, we are referring to loans that have a collateral attached to it. You saw this morning when I was giving the example where the loan terms was that the borrower would pledge its future commodity revenues. That's a secured arrangement. So when the lender is, if you're unable to settle your loan, for example, the lender can go after the country's assets, whatever asset has been put under a collateral. The corollary is unsecured. And this is where we say a loan is unsecured because the creditor is trusting in the full faith and sovereignty of the borrowing country. And so that means we trust Burkina Faso so much that we know that if we advance this loan to them on the faith of their sovereign capacity, they would pay back. But maybe there's a country called Mauritania, and Mauritania is known for so much corruption, bad governance, political instability, and the creditor says, you know what, Mauritania, you are rich in oil. We would only advance loans to you if you attach or you collateralize some of your oil deposits. So that's effectually what this is all about. And either of these loans, for the most part, mostly the term loan or the revolving loan, or even usually both of those two, can be syndicated. And what do you mean by syndicated loan? A loan is syndicated when only one party or only one creditor is either unable or unwilling to undertake provision of the credits to the borrower. And so what that means in effect is, for example, you may have heard Dangote, the richest man in Nigeria, wanted to build an oil refinery. The oil refinery was going to go up nothing less than 20 billion US dollars. Dangote approaches a bank in Nigeria called Zenith Bank and says, could you lend me money to build this refinery? And Zenith Bank says, of course, we're excited to help you, but $20 billion is too much risk exposure. You know what? We would arrange this loan for you. We'll go and meet 7 other banks, and all of us will take 10% or 15% of this amount and give to you. And so at the end of the day, Zenith Bank will probably give Dangote 1 billion. Another bank that Zenith Bank approached may give 2 billion, and on and on. So the risk is then shared amongst the creditors. Of course, you can understand that the reason why this is important is because if there's a risk of default, all the creditors will share it. And then you can easily negotiate with only one creditor in terms of the core terms, and then those terms will apply to all the creditors. You don't have to negotiate with every 7 or 8 creditor. You have to negotiate with one, and the other ones would either accept or suggest or propose new terms that they like. So I'll move on from this. Guiding considerations. So when you're about, and now we are getting to the very juicy parts. When you, as a debt manager, an official in the Ministry of Finance or the central bank, are thinking of getting to an agreement, a loan agreement, there are a few things you must have at the back of your mind. The first is you must review all the terms and ensure that they are fit for purpose. There are certain terms in loan documents that I review in the course of my work, and given the context, I think this is so irrelevant to be here. And lenders wants to get as much of the pie as they can. So they would include any and every term. Savvy professionals would always look through the terms to say, does this even make sense to be here? For example, you are a sovereign nation, and then one of the representations or the covenants in the loan agreement is that you must be duly registered and incorporated under the laws of your country. That doesn't make sense, because a sovereign cannot be duly incorporated. At best, a sovereign is duly constituted, but not incorporated because it's not a company. But that covenant becomes extremely relevant if the borrower is a corporate organization, a company. But that's not the case with us here. So that's one of the examples of an irrelevant term. So you want to check, is it fit for the purpose? Is it relevant? And so look beyond the financial terms. Yes, Rabi and Toria have done a great job talking about the financials, the DSAs, etc. But apart from that, you will find a typical loan document that I review is anything from 150 to 250 pages. A bond indenture, it's usually called a prospectus. It's even worse. I review about 600 pages of those documents. Perhaps the parts that talk about finances, the interest rates, financial covenants, are no more than, at best, 20 to 40 pages. Sometimes 100 pages, depending on the complexity. What you see in on those documents typically are just terms upon terms that are likely to catch you off guard. And that's why, if you're ever wondering what in the world is a lawyer doing in the finance ministry, that's what he's doing, or should be doing at least. And so, conduct a can I steal analysis of terms. When you see a term in your loan documentation, you want to think, okay, if we sign this agreement, can we still pay salaries? Can we still enter into other agreements? Can I, for example, if I enter into an agreement with Slovenia in a bilateral loan agreement, is there a clause in that agreement saying you must not collateralize or enter into any subsequent agreements? And that's a real clause. It's called the negative pledge clause. Oftentimes we see it in loan agreements with sovereigns, a clause that effectively disables you from taking collateral on your own assets that will subordinate an earlier debt exposure or an earlier creditor. And we'll get to that very shortly. And so there's also the point of check whether the proposed language serves a legitimate purpose. It's enough to say, this doesn't make sense, it doesn't matter, it's not going to happen, strike it off. Now, obviously, also understand your leverage, and your credit rating is one of them, and your negotiation position. Now, here I have to be sincere with you. The stronger your country is on the negotiation table, in terms of how you are perceived, your credit rating, how you are undergoing governance, plays a huge role on how the other side is looking at you, and can determine how much they are willing to absorb from your pushbacks. So when you're saying, can I steal, when you're doing all of this analysis, your creditor is thinking, but you are not very upright in terms of your politics. Your credit rating is below CCC even. You know, there's all of these considerations that sort of reduce your negotiation might. But on the contrary, when you have a strong credit rating, or when you are very creditworthy, or especially if with that particular lender, or in recent times, you've not defaulted on any of your loans, you can come from that position of strength to say, I insist on this because I have good standing. And so it's very important that debt managers are conscious of where the country stands within the wider geopolitical markets. Now, obviously, understand your lender's interest, and we'll get to what their interests are very shortly. And keep in mind that once terms are agreed, and we see this a lot during restructuring, so when the country is saying, oh, why did we agree to this? But how did we sign it? We didn't have the capacity to understand what they wrote. It's very difficult at that point to want to peel back and say, oh no, we don't want to do this. We did not think about this carefully. And that's why it's extremely important that at the time of entering into a new loan agreement, of issuing a new bond, you have not just your lawyers, but also your financial advisors, which most of you are, right? But your lawyers also looking at these documents for you, because that's the time when you can easily say, we don't want this or we want this. Also, beware of these very popular arguments by sophisticated lenders. You see it a lot from commercial banks in the US and the UK. Standard Chartered Bank or Citibank would say, oh, we can't change this, it's standard. This is just what we do in the market. Everybody knows this. Nothing is beyond negotiation. There's nothing standard that cannot be looked at again. So if they say it is standard, look at it within your context. Is it standard for me? It could be standard for a bank. It could be standard for a corporate borrower, but maybe not a sovereign borrower. So look at those standard arguments that your lenders would put forward. Now, deep dive into lenders' interests. What are you trying to get at? And I think this is quite straightforward. First, it depends on the lender we are talking about. If it's a commercial lender, their first objective is not just to get repaid, but to maximize profits. So whenever you go to take a loan with a commercial bank or a company or any organization that has commercial interest, just beware that they may be smiling at you in the first instance because they want to get the debt deal done, but believe that when it comes to, if there's any concerns or issues with that debt going forward, they are not going to be smiling as much because they have shareholders, they have people with interest, corporates with interest that want to have maximized profits. So always note at the back of your mind that your commercial lenders are looking for profit primarily. Your multilateral lenders may not be looking for profits, but you are also pursuing development objectives. And what this means is that they could have a benchmark that does not even consider your political nuances and say, you know what, we just want Burundi to have gotten to this level of GDP debt exposure. Or we want Ethiopia or Eritrea or Somalia or any country really to have paid or retracted on how much they pay public servants. And these are real life conditionalities that some of these organizations, multilateral institutions, have put forward to countries. And then you find out when you sign those agreements, it becomes difficult to implement the conditions that you've asked you to implement. So it's worth thinking about. That's one of the objectives. And for bilateral lenders, obviously, if China is lending to you, you know that China is not just being benevolent. They also have their own objectives. You want to know, why is China lending to me on a platter? Especially if the debt is on a platter, comparably. So I've talked about this, be repaid and manage risks. Right, I think we can go to the next slide. So we are getting to the very, very intense part where all of you will start talking back at me as I've been talking at you. And so these are the typical sections in the credit agreements. You see, definitions sometimes can take about 5 to 10 pages. And, even as a junior lawyer, when I started practicing, it was one of the most boring things. I couldn't understand why we were laboring on just looking through definitions. Like, who doesn't know the meaning of conditions? Who doesn't know the meaning of guarantees? Why do we have to labor so much trying to explain what a guarantee is? Well, a lot of times, when you look through the length and breadth of that agreement, the terms that have been defined are scattered through it. And sometimes terms can be so skewed in favor of the creditor that if you do not pay attention to it at the beginning, at the definition section, when it now begins to apply in a later section, and you're saying, oh, why is this so restrictive? Well, it's restrictive because the definition restricts it. the commitments, the borrowing mechanics, how much is being put down, sorry. How do you repay? These are essential clauses, prepayments, all of those. And we will focus on some of the most telling and most conflicting clauses. And those are these ones. All of them, quite frankly, are very important. But these ones are the ones that people have in loan agreements we've seen over and over again. Sovereigns have had issues and concerns with. It has taken people to courts, a lot of courts. It has led to very bitter restructurings. And so we carefully curated these 7 clauses that we think are very relevant for any debt manager. So the first is conditions precedents. Now, in very simple terms, these are the conditions you have to fulfill as a country before any amount is disbursed under the loan. And then we have many examples. So here, it is primarily used to ensure that the borrower has met the necessary legal, financial, and administrative requirements to ensure the effectiveness and enforceability of the loan. And it can be repeated on each drawdown. And we'll come back to this point later. Now, when you look at a conditions precedent, one of the key questions to ask is, are these even relevant to the credits and to the borrower? When you're asking for presidential signature every time there's a drawdown, how is that relevant? How is that important? How is that not onerous? And how is it even feasible for the borrower that every time you want to just draw down on a particular loan, you need to write to the president to sign? And that was in a particular loan agreement that we had to review. It ties also to, do they impose any undue political or administrative burdens on the sovereign? You have to think about, are these burdens going to be cumbersome for the sovereign to achieve in order to activate or use the loan under this agreement? So this is some of the key questions to think about. And you see examples, official authorizations or required consents, representations and warranties that they remain true and correct. So if you have made a representation that you are a politically stable country, it could be a condition precedent that at every drawdown you've remained as a politically stable country. And so there could be also a condition precedent that before we allow you to draw on this loan, there is no default or an event of default occurring on any other loan. Actually, we'll get to all of this. And the rest are also just examples of the kind of things you would expect. Some of the conditions precedent include that you will continue to remain a member of the International Monetary Fund during the lifetime of the loan. It's a condition precedent. We've seen that several times. Okay, well, whilst we fix this, there are key things to bear in mind when negotiating a condition precedent. The first is to negotiate materiality thresholds or de minimis carve-outs. And by de minimis in law, what we mean by that is when something is just too little to be considered, you want to exclude it, right? And so when you say, for example, you have to ensure that all laws and regulations permit the entering of these agreements, it's important to materialize that clause or that statement to say all material laws. So, for example, a local government law in your country has nothing to do with you entering into a loan agreement, and you want to have that clearly put in place or clearly indicated. And if something is just too little, too insignificant, for example, you could see loan agreements where the condition precedent states that the Minister of Finance must continue to be in good financial standing. And it's very funny because the idea or the wisdom is that if the Minister of Finance is not in good financial standing, they could use the funds for alternative uses or alternative purposes, right? And that is so remote. It's something you want to strike off an agreement as couldn't be a condition precedent. That's going to the personal pockets, perhaps, of the minister or of individual members of the ministry. I think we've passed here. Okay. Right, so also negotiate reasonable effort qualifiers. Now we put a note there that this may not be accepted. And what does reasonable effort mean? It means that, you know, a condition precedent could say, you should ensure that you've gotten all consents required for this loan to be disbursed. And, you know, that could be cumbersome for a sovereign, knowing that within a sovereign system, there's a lot of processes, a lot of administrative procedures. And so you want to qualify that to say you will make all reasonable or commercially reasonable efforts to procure all consents or authorizations as may be required under the loan agreements. So you want to change make best efforts. So you could see best efforts. You could see a statement that says the country, the borrower must make best efforts to obtain all approvals. You want to change that to the borrower shall make or will make reasonable efforts. Best efforts is a very subjective standard. When you say best, to the commercial, best may mean that you have gone from the road to the sea 7 times. Whilst in your own context, best could mean just going there 2 times. So when you put reasonable in law, a reasonable man standard has been defined as a standard that is objectively ascertained by a commercially sound mind. And so the court would uphold that a reasonable standard means you have done what is reasonably expected in that situation. We want to ensure that the conditions related to initial loan agreements are not repeated for each subsequent drawdown. And so you will see sometimes where the drawdown clause would say for every new drawdown, each condition precedent must be reaffirmed. That is onerous. You want to strike that out in any agreement. Your condition precedent should only be agreed at the beginning and not at each subsequent drawdowns, because at the beginning, that's the life of the loan, and you're agreeing to it for the pendency of the life. You don't have to agree to it every time you want to have a new drawdown. And so, of course, ensure that conditions precedents are clear, specific, and not overly broad. And so now we get to the very juicy part. I want you to look at the screen, look at this clause. I've taken the initiative to add a French version so that our French colleagues can follow in real time. And I would like, volunteers to say, what would you change about that clause?
I will change sole discretion. 1.
Okay.
Sole discretion. And
changes to what?
It needs, because leaving it as sole discretion means you've surrendered to the lenders whatever it decides.
Yes.
So the active word there will be lender at the discretion, maybe as approved.
As approved by the government, so the borrower.
Okay.
That's what I would do. Thank you, sir. Does anyone else have anything to add? Please, the Gambia.
Again, that all government, all
should be changed to what?
That relevant, maybe, what's the active word there now? Is it relevant or material? Material governments, yes.
Yes, that's great. I think you have my slides with you, don't you? Thank you very much. The Gambia wants, okay.
Thank you. On my part also, I think the sole discretion should be changed to mutually agree.
Okay.
Of course. I also agree with, instead of saying all governmental.
Okay.
So that should also be changed.
Okay. Does anyone
Yes,
from the
thank you.
French-speaking country? Comoros. Is Comoros here? Is someone from Comoros? Is there a team, a delegation from Comoros? No? Is Comoros all the way there? Comoros, what do you think?
Merci. Là, il y a une disposition unilatérale qui est là, une substance satisfaisante pour les prêteurs. Hein? Et puis, nous aurions souligné aussi les renonciations gouvernementaux. Ça semble ici être un blocage. Voilà, le gouvernement, la partie État a les mains et les pieds liés. Merci.
Okay. So the question is, what would you change in that clause to make it more government friendly?
OK. J'aurais changé sous une forme qui serait satisfaisante pour les deux parties. C'est synalagmatique, c'est contrat. Pour les deux parties. Ouais.
Okay, so you would
C'est
mutualize
synalagmatique.
perhaps the sole discretion to have been obtained, if that's what I understand. Is that correct? Okay. Do we have another, say, Niger? What would Niger change to this clause? Okay, yes, ma'am.
Merci. Et moi, je voudrais aborder dans le même sens que le premier intervenant, en disant que à la seule discrétion, je pense que pourrait sauter, dans la mesure où effectivement c'est deux parties prenantes. Donc, à la seule discrétion du prêteur, donc tout de suite l'emprunteur est quand même lésé à ce niveau. Par contre, on peut également finir le paragraphe en indiquant que ont été obtenus par le gouvernement. Par le gouvernement, parce que pour préciser que effectivement c'est le gouvernement qui devrait avoir les approbations, les autorisations et les renonciations nécessaires pour le prêteur. Merci.
Thank you very much. Merci beaucoup, madame. Thank you very much, because I think you already have my slides, even if you don't have it, and your efforts were very on point. So I would just show you what we would turn it to, and what do you think? And so you'll see here that we've said the borrower shall have delivered to the lender, not because the original clause says shall be delivered shall have delivered evidence in form and substance. But now we've put to the lender to be sure that we are giving just to the lender and not to anyone else. And then in a form and substance that is reasonably satisfactory. Remember the point about reasonably, not just satisfactory, but must be reasonably satisfactory. And then Dr. Ouche here said material governmental contribution. So it has to be all necessary and material. And we made this point during our key negotiation discussion. And then all that point about in the sole discretion of the lender, you can see it's off. It's all consents and authorizations required. We don't want to put anything to the sole discretion or even any discretion of the lender. So as long as they are required for the execution, delivery, and performance of this agreement and the incurrence of the loan have been obtained, that's it. Okay. Can we go forward? There's a question here by, I have to come and know your name because you've been contributing a lot, and I like to know my students. And that's Dr.
For me, it's far too long, that. You can make it very short and simple. That's legal. I mean, sometimes I don't know. I mean, for me, I'm a operator. So why make it so difficult to read, and at the end you forget what it's really about? Just one sentence, quickly, and then you have it. Why all this?
It's a very good question because it seems obvious. Why do we have to go through all this stress when we can just easily say the borrower shall deliver to the lender all evidence necessary? The problem is loan documents are one of the most fought over documents, especially when we are getting to a restructuring or if for any reason there's a litigation or arbitration. You may have heard that a certain country in Africa was sued by a certain African multilateral bank. One of the questions before the courts was in defining what the loan terms are. And the court went line by line, defining everything. And so to the extent that the terms were not favorable to the government, they lost the case. You have to, so as lawyers, we're trained to write as though when we appear before a judge, we would have a favorable outcome. So you leave nothing to chances. And you probably don't have to review this. Lawyers can review this, and we are trained to review long documents. I just told you I reviewed 600-page documents when I was working in a law firm, sometimes twice in a day. Yes. So this is our work. That's why we go to school for 7 years or whatever. But it's important because of the implications. Can we please get the mic to Anja?
Thank you very much. For me, I was thinking the word delivered should be replaced with provided. Because,
Okay.
when you talk of delivering, it's like a hand-to-hand, or there's something to show, but you could provide by not necessarily going through post, going through whatever it is. I think provided would be better than delivered, because we've had cases in my office where we were initially demand notice were delivered to us by post, but now they are provided through email and other things and makes things faster.
Yeah.
That's just my opinion. Thank you.
Thank you very much, Adja. And it's a very good point. And the reason why it's a good point is because usually in the definition section, mode of delivery is defined. And so it could be defined as by post, by email, or by hand delivery. So that would affect, and that was the point I was making about the definition section. If you don't review that, you don't know what applies to the rest of the documents. And that's one of the cases here. So thank you for pointing that out. And again, I want to also flag that this is not final. It's subject to your inputs. In your practice, you may have seen that, oh, this is a bit difficult to get done. And that's why we're here, to share perspectives. Okay, I will take one more, and then we'll go to the next because of time.
Ok, merci bien pour la présentation. Moi, ma préoccupation, c'est en fait les autorisations et les consentements liés aux tiers. Ici, on pourrait effectivement poser la question de savoir quelles sont effectivement ces autorisations-là pour avoir plus de précision. Voilà, parce que si on laisse ça en l'état, ça peut être, si on n'a pas tous les éléments qui entourent effectivement ces autorisations, qui ont un lien avec la signature et notamment la mise en vigueur de l'accord, effectivement, à un moment donné, ça peut être un élément de blocage. Donc, c'est mieux effectivement qu'il y ait des éclairages également sur ces autorisations des tiers. Merci.
Thank you very much. It's a good question also. So it makes sense to define in the definition section what third parties constitutes. But in this case, we've qualified that whole phrase with necessary and material. So if there's any third party consent, the reason why that is there is because the lender may not know what arrangements the government has in place. And so there could be arrangements with third parties. For example, if the government has a contractual construction agreement with a company, and then that construction agreement is interfering with or might interfere with a future loan document, the lender is not obligated to know all of the arrangements of the government. So this third party would relate to anything that is relevant or necessary and material. And you can see we now added required for the execution, delivery. Doctor, you see why this is important? Because now we have defined why or how the third parties relate. Whoever they are, they must be necessary and material, and they must be required for the execution and delivery and performance of the agreements. So whilst the lender may not know all the third parties that the government has a relationship with, we have confined the class to only people who are relevant for the execution and performance of the agreements. Okay, I will go forward. So this is another clause that is often contested. And remember, these are some of the most contested clauses that we have seen in this practice area. And that's representations and warranties. So effectively, they allow the lender to continue to assess the transaction's risks and to confirm the borrowing status of the borrower. And so what does a representation mean? It's a statement of truth about the borrower that is made at the beginning of the loan life cycle. And effectively, it is saying that in order for you to give me this loan, I am X, Y, Z. For example, I am the Federal Republic of Ruritania, and I have 50 billion US dollars in my reserves. Now, you want to be sure that the statements that you're making are not false, and all of these statements are typically what would allow the lender to advance funds to you. So the lender feels comfortable when he hears that you have $50 billion in your reserves. But if you are lying about that, that could be or could lead to an event of default. And we'll get to the events of default. So the quick questions again are similar to conditions precedents are these relevant to the credit and to the borrower? So if a representation says that you should represent and warrant that you are duly incorporated as a country, that's irrelevant. You can't have that. Are these feasible for the borrower? So if the lender says you have to, during the pendency of this loan, you have to continue to have a certain amount of money in your reserves. Well, your reserves could be tampered with during the life cycle of the loan. Anything could happen. You don't want to make a representation that will make it difficult for you to govern. And so you think also about if they impose any undue political administrative burdens, and if there are representations that the borrower can truthfully make. Do not let any lender compel you to make a representation that you know is infeasible or just simply difficult. So examples of representations and warranties include that you have no conflicts with other obligations in your purview, or that the obligations are binding on the borrower. Of course, you have to represent that you agree that these obligations under this loan agreement is binding upon you. You also have to agree that you have the power and the authority to enter the transaction. So we've seen cases where a country has just undergone a coup d'etat, and then the new, perhaps it's a junta government, a military government, are trying to contract with a company for debts. And this happened. Saddam Hussein's junta and oil companies in Russia. And of course, Iraq came many years later to say, oh, Saddam Hussein's debts were odious debts. He didn't have the power or authority to contract on behalf of the state of Iraq. To what extent is that argument viable? It's an open question. Anyway, so moving on, we have governing law and judgments obtained will be recognized and enforceable. Obviously, your lenders will want to know that if for any reason you're unable to pay your debts, they can enforce against your assets. It's a representation lenders will ask for. And then they would also ask for pari passu status, which you can see is in bold here, and we'll get to this more deeply later. There's also the point about the borrower complying with treaty obligations. If for any reason you have entered into the nuclear treaty, the lender may want to confirm that you are actually aligning with the terms of that treaty, if, again, it relates to the loan that has been advanced to you. And that, again, the sovereign maintains IMF and World Bank membership. These are some of the representations that lenders often have asked borrowing sovereigns to confirm. So key tips, again, we are going to another assessment to think about this as we go to the next question. Negotiate materiality thresholds. If there's anything that you're asking you to do or to check, ensure that it is a material and necessary obligation, not just any obligation. Try to negotiate for a knowledge qualifier. So what this means is the clause could say the borrower represents and warrants that it is fully settled all of its debts in other agreements. And the reason why a lender will put this is because they want to know that you are keeping up with your debt obligations and hopefully you will keep up with theirs. Now, the way to go about that is to say, to the best knowledge of the borrower, they are keeping all their debt obligations in check. So you want to add the fact that it's to your best knowledge. The reason why that is important, again, is because government processes are long, often. There's series and series of approvals from office to office. Somebody may have dropped the ball, and if you go and make a representation that you've absolutely confirmed that this is the case, and it happens that it's not the case, it's a misrepresentation. And so you want to say to the best of your knowledge, this is the case. Ensure the representations focus on areas that are relevant to sovereign borrowers. We've talked about this already. You can't be talking about issuing share capital, for instance, or being duly incorporated in the country, because a sovereign would not issue share capital, neither would it be incorporated in a sovereign, under its laws. So again, just like conditions precedent, ensure that representations are related to the initial drawdown only and are not repeated. You make them once, you don't have to keep on making whenever you draw down. Okay, and so make sure each representation is accurate and can be made. Now we put on our thinking caps and confirm how we would change this clause. Somalia. Yes, sir. And you can take time to think about it before you respond. It takes like 2 seconds to think about it. And by the way, just to add that all of these clauses on the screen that we are putting here are real-life clauses that we've seen in loan contracts. And perhaps they're in some of our country's contracts.
My suggestion is, briefly, I want to talk something else about the Saddam Hussein clause, but I'll ask you that question later on. But when it comes to Istanbul 2,
thank you. We'll come to questions later.
Okay.
Thank you.
But this one, I'm not that sure, but I would, if I have to alter something, I would accurate and complete. Accurate and complete as that would be something that is, because you are not always free from material, it's correct to me, free from so a word like that, I'm not I'm not a lawyer, but something close to the materiality. So instead of accurate and complete, I would have changed those 2 words.
That's very good. You've identified the problem with that clause. That's very good. And what would really change here is to add the qualifier I just talked about, and that is to the best knowledge of the borrower. It's all complete and free from material errors. So if for any reason it is indeed not complete or not free from material errors, well, you represented to the best of your knowledge. So perhaps your best knowledge wasn't the best, and that's okay because of this addition. I'll go on because of time. And again, of course, keep your questions. I know there could be questions. Keep it and we'll. Mr. Chidi, did you see why I said we have to take this to the next session? Because there's quite a number of really important things. Okay, thank you, sir. Komurus, is there a question? Okay. Is it?
On ne peut pas affirmer avec exactitude que toutes les prévisions macroéconomiques et la croissance économique sont exactes. Et vous savez, tous les pays, c'est comme ça, on projette. La plupart du temps, ça ne se réalise pas. Donc, on projette dans l'avenir. Les prévisions macroéconomiques, c'est des estimations, c'est des hypothèses. Donc, vous ne pouvez pas tout de suite affirmer que ces hypothèses sont vraies. Au moment où c'est des prévisions, ça va venir. L'avenir se chargera de le confirmer ou de l'infirmer. Merci.
It's a good point. And that is exactly what that language does, to the best of the borrower's knowledge. So it doesn't have to be accurate, but that language accommodates the possibility of inaccuracy. There is no court you will go before, there's no arbitrator you will go before that will hold you accountable for an error in an economic statistic when you have a language that says it was imputed to the best of your knowledge. Oh, there's another sample clause that says the borrower represents and warrants that no litigation, action, arbitration, administrative or other proceedings before any court, tribunal, etc. have been commenced or threatened against the borrower, any of its agencies, or any of its assets. Obviously, this is an extremely problematic clause because you can't make that kind of representation. Not just against you, but any of your agencies, you can't make that representation. And so we typically correct this by adding a lot of language. So first we have to the best of its knowledge, and then we had a materiality threshold as to how much is involved in the litigation. So no de minimis litigation. A litigation of 100,000 USD may not be material enough. Because if 100,000 is in litigation, there's a chance that there's tons of litigations that will be implicated. So we will typically include a threshold of, and 100,000 is fictional. It could be material depending on the circumstances. And that if adversely determined, will reasonably be expected to have a material adverse effect on the validity. So again, you are tying any such litigation to disagreements. So if there's a litigation that does not concern or affect the agreement, it shouldn't invalidate this loan agreement or the ability of the borrower to perform its obligations under this agreement. So these are the only two reasons why a litigation happening against the state should be allowed to be material under a loan agreement. It's either if it's affecting the borrower's ability to pay or its ability to perform its obligations under the agreement. Otherwise, it's irrelevant, it's immaterial. Okay, so this is the French version. Sorry, French. So we want to look at it a bit. C'est bon? Okay. Covenants. So covenants are usually statements that countries make or borrowers make of things they will do or not do during the life of the loan. And so the key questions, again, as like before, is to ask, are these covenants reasonable? Do they conflict with other sovereign obligations? You can't enter a covenant that impedes you as a sovereign from being able to undertake domestic affairs, that impedes you from conducting an election, that impedes from paying salaries, or that are against your local laws. And so you also think about, will it restrict the borrower of carrying out his daily activities or to comply with his eternal capacity, needs, or pressures? So, again, common covenants will remain maintaining of membership status with international organizations, complying with World Bank. Sometimes you could see covenants that say you have to comply with West African Economic Monetary Union debt threshold. You could see covenants that say you have to comply with the international financial transparency measures. You see, and you want to be sure that it's something you can actually covenants to do. So we also see negative pledge as a covenant, and we will deep dive into this and pari passu. So, deep dive into negative pledge. And negative pledge is effectively a borrower saying that they would not undertake or incur an obligation that would supersede the present obligation. I'll give an example to make it simple. Chad has lent money to a bank. A bank has lent money to Chad. And then the lending, the terms of the loan, was unsecured. You remember the unsecured points we made earlier? It was not collateralized. And so it was made in the good faith and sovereign capacity of Chad. And this was in 2024. Just last week, Chad is thinking of taking another loan from China. And China insists that Chad must attach or collateralize its oil reserves or oil revenues before they can advance that loan. Now, if in the loan agreements between Chad and that first bank contains a negative pledge clause, Chad would not be able to enter into this agreement with China. Because if they do and give China collateral, China would have, if there's a restructuring or there's a need to enforce payments, China will be seen as a senior to the bank that took the loan, that gave loan to Chad even before China did. And that is the doctrine of priority or ranking in law. The person that has a secured loan ranks higher than the person that has an unsecured loan. And so to protect themselves, when a lender is entering into an unsecured loan, they would insist on this clause that you will not take an asset, you will not take security over assets that will supersede my interests in your country. Well, the World Bank has a template clause. If you enter an arrangement with the World Bank's clause would say, if you ever create a future secured agreement with any lender, we would take the same position. That means you have taken the same security for us. And what that means is, assume the World Bank is the bank in this example with Chad we just gave. Is the microphone working for French? Is it working? The Français? It's working? Okay. So assume that the World Bank is the bank in this Chad example, and Chad wants to take another loan from China who wants security. The World Bank's clause, standard clause, is that the moment you give China security, you've automatically given us security as well. So we and China are now ranking on the same pedestal. So it's important to be aware of this. So this is an example of a negative pledge clause. The borrower undertakes that so long as any amounts remain outstanding under this agreement, it shall not create, permit to subsist, or grant any lien over any of its present or future assets, revenues, or rights to secure any indebtedness. That is problematic. I know I've not talked about how to negotiate it, but does anyone have any preliminary thoughts? What is problematic about this clause? And think about it as a debt manager who is going to incur $300 million. Any takers? The Republic of Congo, DRC, it's a wonderful country. Can we please hear from the DRC? What do you think? Any thoughts? Later? Perfect, no problems. Madagascar, what do you think? Perfect, there's a taker from Madagascar there.
Oui, alors, le problème de cette clause, c'est que l'emprunteur ne pourra pas souscrire à un autre prêt et ne pourra pas garantir ses actifs à un autre prêteur tant qu'il n'aura pas payé sa dette. Donc, il faudrait changer que l'emprunteur n'aura pas cette exclusivité ou peut-être mettre un taux, mais ne pas empêcher complètement la garantie auprès d'un autre prêteur.
Okay. RDC?
It's a good point, but how do you change it? How do you change? So she said that the problem with the clause is that the borrower will not be unable to extend facilities or take more loans from another lender, and that is too exclusive, which is a good point. But how do you make it less exclusive? And just to save our time, first thing to think about is that the question of what a lien or debt must be changed. We have to define what is a lien, because the reality is, for the lender's sake, they also, okay, Congo now has a response. Okay, 1 second. Oh, you know what, just go on, since I'm giving the answer and you want to give an attempt. Please go on with your intervention.
Merci. Nous avons connu ces cas. Dans notre portefeuille, nous avons évidemment des dettes envers des multilatéraux, des commerciaux et des bilatéraux également. En 2008, nous avons conclu un contrat avec la Chine, la Convention sino-congolaise. Il était question pour nous de garantir nos mines. Et on a été contraint par la suite de remodeler le contrat tout simplement parce que, au fait, il y a eu cette question de la garantie qui s'est posée. Les mines garantissent tous nos créanciers. Alors, à un moment donné, dire que ça ne concernerait qu'un créancier, ça a dû poser problème. Et du coup, on a revu la structuration du contrat. Et alors que le montant initial était de 6 milliards, ça a été baissé à environ 3,5 milliards. Donc, nous pensons que c'est une clause qu'il faut bien regarder pour ne pas mettre les créanciers, l'ensemble du portefeuille de créanciers en difficulté. Merci.
Okay. Thank you very much for the historical on how you dealt with a similar situation. For the purpose of this class, and just to make this, how to make this less lender-friendly, one thing to think about is the definition of a lien. Now, I have to put it to you that there's really nothing much you can do about a negative clause, a negative pledge clause. Because the lender, one of its primary goals is to ensure that it gets its money back. And so if you fight this, what you're saying to the lender is, I cannot assure you that we'll be able to pay you ahead of someone else. And no lender wants to be put in that position. And so what you can do is to add carve-outs. First of all, a materiality carve-out. So it could be that this would apply provided that the new loan to be taken is not less than $1 million or $100 million. So if it is a small loan, it should not trigger negative pledge. If you're only advancing the loan to, for a small purpose, negative pledge should not be triggered, because it may not. The wisdom behind that is that a small loan will not trigger or will not impact necessarily your ability to pay the first lender. In theory, again, these are negotiation points, so it's something to put forward to. But remember that a loan agreement is an agreement. The lender has to agree. But I'm saying that you have options of arguments to make. The second thing you can think about putting is to redefine what a lien means. And so lawyers will typically change lien to be an external indebtedness so as to expressly exclude internal or domestic loans. The idea is what the lender, especially if it's an international lender, cares about is FX, is foreign exchange, currency. And so the wisdom behind that recouching is that monies advanced in your local currency will probably not be the business of an international bank, because they will not want to be paid in your local currency in any case, especially if it's a euro loan. And most loans are euro loans, international loans, right? So if it's a domestic loan, now there's no guarantee that they would agree to this. It's an argument still being made within the sovereign debt sector, but countries have put this forward as a viable alternative to having it as plain as this. Another carve-out to consider is to carve out your reserves. Your central bank reserves can never be part of the bucket or perimeter of things that we considered as being encumbered. I will just show you now so we can go on our break. I think it's already time for break. What a revised clause could look like. These are the key tips. I've already mentioned all of this. Here's what a revised clause looks like. So you see, we say public debts, public external indebtedness as debt in an aggregate principal amount exceeding threshold in brackets. For the avoidance of doubts, the foregoing shall not apply to pledges and liens in relation to liens required by law. I should have mentioned this as well. And so, if there is a lien that is required by law, for example, paying salaries is a lien on the government. The government must pay salaries. And so a creditor cannot say the government should pay them instead of paying salaries to its public servants, or as required by international financial institutions for development purposes, for central bank operations, or liens on project-specific revenues and small-scale secured debts. So this is one good way to water down the effects of a negative pledge so that it's easier for you to bear. But you cannot exclude totally this clause. I think we will take a pause here for lunch, and then when we come back in the afternoon, we'll continue on, I believe it's pari passu. Thank you very much for your listening time.